Okay, we'll just give it, it's 12:03. All right, we're gonna go ahead and start. My name is Pam Bridge. I am the Director of Advocacy and Litigation at Community Legal Services. We normally do webinars every Friday on different areas of practice at Community Legal Services, and those are always free. However, because the CDC eviction moratorium is so important to all of our tenants and landlords throughout Arizona, we needed to do this on a special presentation. But I did want you to know before we start that this Friday, September 18th, we will be doing our noon webinar. That's why I had my times messed up. We'll be doing our noon webinar on SSI and SSDI overpayments and how individuals can manage that through self-advocacy. You can sign up for that just the same way you signed up for this one. And then on September 25th, we'll be doing one on the CARES Act and federal student loans. So again, we welcome you to those Friday lunchtime webinars. Now, during this presentation, you'll be muted, but please feel free to type any questions you have in the Q&A. And at the end of the presentation, I will try to get to as many as I can. I can't give legal advice during this webinar, but I can give you legal information. That means that during this presentation, I can't advise you on your specific situation and what you should do. However, you can contact Community Legal Services and become a client, and we can provide advice, and I'll let you know how to do that in just a minute. I also want you to know that this webinar will be on our website. And this will be posted on our website, all of the slides. And also, if you email me, I can send you the PowerPoint also. Today, we will be covering the CDC eviction moratorium and the Governor's Order 2020-49 and how they interplay. I want you to know that this presentation is really geared for tenants. We're not anti-landlord or their attorneys, and they're always welcome to our presentations or to any of CLS presentations. However, because 99% of tenants are unrepresented, we really especially gear these presentations to tenants because they really need this information at a time where so many people cannot pay rent. However, it helps landlords also to hear these rules. So you're welcome too if you're a landlord. And I also want you to know if you're a landlord and you're a pro per landlord, that means that you don't have a landlord attorney, that the Arizona Housing Coalition has a toolkit on their website for landlords. So there is information out there also specially geared for landlords. So just a little bit about CLS. We are a nonprofit law firm. That means that we do not charge, that strives to assure fairness in the justice system, no matter how much money you have. But we do provide direct services, meaning we can represent and provide legal advice to individuals who fall below 125% of the federal poverty line. However, we can give legal information or basic information like this to anyone regardless of your income. We assist people not just with landlord-tenant issues, but as I discussed, the other webinars coming up, we also represent people, assist people in employment, consumer, health and economic stability like Access and SNAP and SSI, and also family law. All of our advice, all of our information, all of our services are free to the public. Sorry, 1 second. We are located in 5 counties: Maricopa, Yavapai, Mojave, La Paz, and Yuma. We can give legal information to everybody all over the state, but we can only represent and provide advice to people who are in our counties. However, if you're talking to us, if you're coming from one of the other counties in the state, Southern Arizona Legal Aid assists individuals in the southern part of our state, and DNA assists individuals in the northern part of our state. And I'll show you the website at the end of this, how you can contact us and those organizations. Just how to reach community legal services. If you have any legal issues that I mentioned, you can call us at that first number, 823 in Maricopa County. It's important to know that even if you're in our other counties, you can call that number. We have an awesome triage unit who can assist you, then direct you to the right county. And I'm excited to let you know that if you're a tenant at risk of losing your house, even if you have already had a judgment and you're within the city of Phoenix, we have a partnership with the city of Phoenix right now that we can assist all tenants in that situation, regardless of your income. You can just call the number 602-385-8880, and we have wonderful new attorneys and paralegals who can assist you. Okay, let's get into it. So I have to give you a little primer on eviction law. Don't worry, not a lot, but you have to kind of understand the process to understand the CDC role and the governor's executive order and how they interplay. So basically, and we're going to focus on non-payment of rent because that's really, well, that's 77.5% of all of the evictions in the country are non-payment of rent. And also that's who both of the CDC order and the governor's order really try to target. So first, let's say you can't pay rent on the day your rent is due on your lease. Your landlord gives you then a 5-day notice of termination. That means that you have 5 days to pay your rent and any late fees. If you own your mobile home and you rent the space, you'll receive a 14-day notice. During that time, if you pay any part of your rent during that month, and the landlord accepts it and doesn't make you sign a waiver, you will not be evicted that month for non-payment of rent. You will still owe it, but you will not be evicted. So always, that's one of the common themes we'll be having today, always try to pay what you can. Also, so at the end of the 5 days, and these are the factors before COVID and after COVID, but you need to know them so for the laws that we're discussing. So if you can't pay rent within the 5 days, then the landlord can file a complaint against you and give you a summons. As soon as he files that complaint, you cannot stop the eviction for non-payment of rent unless you can pay rent, late fees, court costs, and attorney's fees. And most landlords, not all, are represented by attorneys. Then you'll have a hearing. Right now, most of the hearings are by phone. And again, even during that hearing, if you bring that rent with you, if you bring those funds with you, you can stop the eviction until the moment that the judge issues the judgment. And the judge will issue a judgment against you if the landlord did the process correctly and you do not have a valid counterclaim. At that point, if you do not have the money owed, the judge will give you a judgment. Once that judgment is issued against the tenant, then the tenant will be evicted unless the landlord agrees otherwise, and always have that in writing. Also, that judgment stays on tenants' records for up to 7 years. So that's a point where we want to try to avoid getting that judgment on the record. For non-payment of rent cases, then the landlord 5 days later can get a writ of restitution. a big word, but what it means is that the sheriff or constable can lock out the tenant. That is basically the process. It's one of the quickest in the country. Basically in 2 weeks, from the beginning to the end, a tenant can be locked out. So now that you know everything there is to know about non-payment evictions, we're going to get into it. The CDC order basics. Basically, on an overview of it, before we get to the details, is it lasts until December 31st. Also, if the tenant gives a required declaration, it stops the landlord from giving a notice of termination for non-payment of rent and eviction complaints for non-payment of rent. There can be no judgment then for non-payment of rent against the tenant. However, rent, late fees, and interest continue to be owed, and there are substantial penalties for the landlord or the tenant who violate the order. I want to point to the second factor that in Arizona, we're a little bit fortunate right now because our courts have stated that the CDC order stops the entire process, that tenants cannot receive an eviction complaint for non-payment of rent if they have given the appropriate declaration. You may have read in the New York Times, Matthew Goldstein wrote an article that said that states throughout the country are doing this a little bit differently, and some states are not interpreting it as broad as Arizona. Many are. So we are fortunate right now that our courts have stated that it stops all evictions for non-payment of rent if the tenant has done the declaration properly. So this is a lot of little details that we need to get into. I apologize for the spacing, not sure what happened there. Okay, so the CDC order applies to all tenants on the lease who are properly on the lease. So if you have somebody that the landlord doesn't know about and they're not on the lease, this is not going to apply to them. However, it applies to all tenants on the lease, and we'll talk about this, but all adults on the lease will need to sign this appropriate declaration. There's also some financial requirements. You have to expect to earn $99,000 or less in 2020, or if you're filing jointly under 198, or you are not required to report income in 2019 to the IRS, or you receive the stimulus check. If you are one of those three options, then the CDC order can apply to you. So it's exciting that this reaches people who are not just low income, a broad amount of people. However, $100,000, if you earn $100,000 or more, the CDC order is not going to apply to you if B or C also don't apply to you. Now, the next part of this is that you have to be unable to pay rent because of substantial loss of household income due to loss of hours of work, loss of wages, layoff, or extraordinary out-of-pocket medical expenses. And they defined medical expenses to be unreimbursed from your insurance that are likely to exceed 7.5% of your adjusted income before taxes for the year. What's important about number 3 is that two things. Number one, it doesn't have to be related to COVID. You just have to have a substantial loss of household income due to any of those things. A lot of those factors are related to COVID, but that doesn't have to be related to COVID. And also, there's not a time limit on that. The order doesn't say that you had to have this substantial loss of household income during COVID so that before you made money and because of COVID now you make less. You could have gotten a job during COVID-19 and then lost it. So if you have substantial loss of household income to any of those things, and again, there's not a time limit on it, then this would apply to you. We just had a case recently, though, where someone was receiving SSI for several years, and they didn't have a substantial loss of income to any of those things. They have been pretty the same amount of income every single month. And then it's not going to apply to them because there has to show some loss of household income, some change in income that's happened because of these factors. Also, if evicted, the tenant would likely A, become homeless or need to move into a homeless shelter. B, need to move into a new residence shared by other people who live in close quarters. You can see in both of those situations, they're worried about people spreading COVID. C, have no other available unoccupied housing option that would not violate housing standards. So they're basically saying you're not forced to live in places that are violations of code violations, that there's no available housing that is appropriate and that doesn't violate code violations. And then I like number D, that there's no other available unoccupied housing that would not result in an increased housing cost to you. That means that this applies to you if there's no other housing available to you that you wouldn't have to pay additional rent. There's nothing that's going to require you to spend more money on rent than this CDC applies to you. And then 5, even though it's small, it's pretty huge. That you have to, these are for tenants who have used their best efforts, and they use past tense, to apply for all available government rental assistance, and they are paying the rent that they can, and I will get into that. So these tips, you don't have to memorize all those things I just went over. This is a tip sheet that's on our website. But this is what the declaration has to say, that I've used my best efforts to obtain all available government assistance for rent or housing. So that means that that's something that if you're a tenant who thinks you're going to have problems paying rent, you should be applying for government assistance right now. Just do it right now. You can't sign this document, a declaration, if you haven't applied for rent assistance. And then you should it's really good to keep any documentation that you have that shows that you applied for all available government assistance. And there is a lot of government assistance for rent right now. You can go on the Arizona Department of Housing's website, and it shows you a list of where you can apply for rental assistance. There is some time that it takes. It's getting faster. But you need to get that application in as soon as possible and make sure that you are getting all of the documents that you need to give to them so that you can get that rental assistance. Number 2, we talked about that I expect to earn no more. That's the financial requirements, that you have to earn less than $99,000 or not be able to have been able to report income in 2019 or receive the stimulus check. That you are unable to pay your full rent because of a substantial loss of housing income. And then I'm using my best efforts to make timely partial payments that are as close to the full payment as I can, taking into account all of other critical expenses. So you have to try to pay rent as much as you can. And you have to make good faith efforts to do that. We know everybody's struggling, but you need to pay what you can. And you want to do that for your benefit also, because this protection only runs until December 31st. And we have all had a hard 2020. And you don't want to wake up on the first day of 2021 and owe all of this back rent and face that short-term eviction that I just went over in the beginning of this. We want 2021 to be better than this year. So you want to try to pay rent because all of this rent is going to be owing, and you don't want to be evicted in January 2021. And you've got to use your best efforts to try to pay what you can. Again, if you're evicted, I would become homeless, or I'd have to move in close quarters with other people, or there are no available housing options for me. And as I said, that is defined as housing options are defined by housing that that is not in violation of any code problems, and that is not more expensive than the rent you're currently paying. You understand that you still must pay rent and comply with all of the lease, and that late fees and interest are going to accrue, and that on beginning January 1st, the landlord can file a non-payment of rent case against you. And this is key. I understand that any false and misleading statements may result in criminal and civil actions or fines, penalties, damages, or imprisonment. And then I certify under penalty of perjury that the declaration is true and correct. So we have a sample in English and Spanish that you can use. The courts also have sample declarations that you can use on their website. And what I'd like to point out, a couple things about this declaration is you'll see when you look here that every adult in your unit who is on the lease has to sign this declaration. If there is a problem and they can't sign, maybe because of a disability, then you need to write that down and the reason that they can't sign it. There's only 4 lines, but you can add lines to sign. It's really important that you keep copies, that you give this to your landlord and you keep copies of it. If something happens and the landlord still files a complaint against you, you're going to want to either bring this to court or on the day of your eviction hearing, or email it ahead of time to the court, however they want to see your documents. And you can find out by calling the court, the court. But you want the judge at your hearing to see that you gave this declaration to your landlord. You can still give it to your landlord for the first time at the hearing, but you know, it's always better to do it before, so you're saving everyone time. A couple questions. So does this apply to all types of evictions, not just non-payment of rent? No. A landlord can still evict a tenant that engages in any of the following: criminal activity on the premises, threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to property, violating health and safety codes, or violating other things on the lease besides non-payment of rent. I'll let you know that there is a little bit of debate about, or not a little, a lot of debate about whether the CDC order applies to people who whose leases are not being renewed. So that let's say you're on a month-to-month lease and your landlord decides not to renew your lease. In that situation, the Maricopa County courts have stated that the CDC order does not apply. People are deciding that different ways throughout the country. I would argue that if your landlord is giving you a 30-day notice for non-payment of rent, I'm sorry, a 30-day notice to not renew your lease, and the landlord's doing that because you didn't pay rent, the landlord figured out that they can't give you a 5-day notice and they give you a 30-day notice, then the CDC order, then it's basically the same thing, and the CDC order applies. So I think there's an argument there. if the reason the landlord is not renewing your lease is because of non-payment of rent. This is tricky because I want to let you know that the Maricopa County courts have stated that they do not think the CDC order applies to non-renewals. So you're going to need to probably call Community Legal Services, or it's a risky way to go in those situations. What happens if the landlord or tenant violates the order? There is a $100,000 penalty for violating the CDC order. Landlords should not evict tenants who comply with the order, and tenants should tell the truth. Don't sign it to delay, and don't sign it if you haven't done these things. It's too much of a risk. And basically, a lot of these requirements, they're not that hard. You know, basically apply for rental assistance and do these things, but tell the truth. Don't give this to the landlord if you haven't done these things. If you, as a tenant, haven't completed one of the requirements, maybe you meant to apply for rental assistance and you haven't done it yet, apply for rental assistance, and then sign this document. I want you, tenants, can the landlord still charge me rent and late fees and get an eviction judgment against me? You will still owe rent. Like I said, January 1st, all of his rent could be due. And you as a tenant should pay the landlord whatever amount that you are able to pay. Really try to do that. And if you provide the landlord the declaration, however, the landlord cannot file an eviction, cannot get an eviction judgment or file a complaint against you until after December 31st. Again, after that date, you can get a complaint. We talked about extraordinary pocket medical expenses, what that looks like. Do I need to get this form notarized? No, you do not need to get it notarized. However, it's important to know, like as I went over it, that this is being signed under penalty of perjury. Another nice thing about the CDC is that you don't have to supply any supporting documents. You don't have to show copies that you applied for applications. You don't have to show any available documentation that you have about your substantial loss of income. That's really, really important. All you have to do is, if you've done all those things and it's true, you just have to sign the document and give it to your landlord. That's all you're required to do, no other documentation. A copy of these notes are also found on our website, and we also state where you can get rental assistance. And again, every adult on the lease needs to sign the declaration. So let's talk about the governor's order, 2020-49. So we went through that process, and the key thing about the governor's order is that it only delays being locked out from the constable or sheriff. This was the second, we had 2020-14 executive order first, and then this order began August 22nd and just runs to October 31st. And the three requirements for this are that you give your landlord a notice of ongoing COVID-related substantial financial hardship and available documentation, that you complete an application for rental assistance at a nonprofit or government agency, and that you ask your landlord for a payment plan and propose a payment plan with your landlord in writing. So those are all of the three requirements for the governor's executive order. One of the important things to know about the governor's executive order is that previously, before August 22nd, it was fine if you had COVID or a health condition that made you at risk for having COVID, and then you could receive this delay. That changed on August 22nd. Now, you have to have an ongoing substantial financial hardship as a result of COVID-19. And that can be as job loss, reduced pay, your workplace is closed. if you are in the hospital with COVID, but you can still pay rent, that's not going to be good enough. You have to have ongoing substantial financial hardship. And then so you have to give notice to your landlord of that. And then the two other additional requirements again are completed application of rental assistance and proof that you are attempting to make a payment plan with your landlord. We have a copy of that notice in English and Spanish, and the notice that I just posted on our website that you can use. Just like with every notice, we always say this so many times every day, but if you give a notice to your landlord, make sure you keep a copy of it. And all of these notices can be text or emailed to your landlord. Differences between the CDC order and the executive order. You probably picked up on some already as I was going. But just to be clear, for the CDC order, the tenant just has to provide a declaration in writing, that declaration. It can't be any declaration. It has to say the things that the CDC said it has to say to the landlord. That's all. For the executive order, the tenant has to provide notice of the substantial ongoing financial hardship related to COVID, proof of the completed rental assistance, and the payment proposal. The CDC order, extremely, extremely broad. If the tenant does that correct, the landlord cannot give the tenant a notice of termination for non-payment, eviction complaint, or receive a judgment against tenant, again for non-payment. Under the executive order, the tenant can still receive a complaint and eviction judgment. Again, that eviction judgment stays on the tenant's record and makes it really difficult to find another place to live. The CDC order, loss in substantial household income does not have to be related to COVID-19. Under the executive order, tenants must have an ongoing substantial financial hardship related to COVID-19. The CDC order ends December 31st, and the Arizona order ends October 31st. So the CDC order, I talked to you about the dispute, about the lease termination, so it may or may not apply to lease terminations. Again, the Maricopa County courts have said that it does not apply. The Arizona executive order, they have said, courts have said that it does apply to lease terminations. So that maybe if you can't get the CDC order, you can at least not be locked out if it's a lease termination. And then the other population of people in which would not be covered by the CDC order that would be covered under the executive order would be if you have really high income, if you have $100,000 or more, but you are having substantial ongoing financial hardship that makes you not able to pay your rent, then you could fall under the executive order. Just to really spell it out pretty easy, remember my chart I showed on the Arizona non-payment evictions 101? So you see that the CDC order applies because the landlord may not take any steps if the tenant has done these things correctly. That the CDC order covers all of these things and protects the tenants from all of these steps, whereas the executive order just can delay this last step. Again, all of these things can happen begin January 1st. So this is a delay. So the CDC can delay all of these things until January 1st, or the executive order can just delay it to the end of October, just being locked out. So a couple takeaways when you can't pay rent, right? Number one, communicate with your landlord. You know, you don't want your landlord to say, I haven't heard from the tenant. I have no other choice except to begin termination proceedings because I haven't heard from them. You don't want that to happen. Communication with your landlord and having a good relationship with your landlord is always good, not just when you can't pay rent. That's a great thing that you should try to do. The second is you want to decide if you want to remain in your property. Remember, as we always say, the tenant, you're the consumer. If your landlord wants to not renew your lease, or maybe he doesn't want to work with you, maybe he really wants to evict you beginning January 1st, and maybe you know that you lost your job, and although you're hopeful, you know that even in January, you're not going to be able to pay that rent. If looking at the long-term solution, can you remain in this place? So what you may want to do is let your lease terminate then and turn in the keys and move out. If you can't pay rent, you will still owe a money judgment to your landlord, but you won't have an eviction on your record then if you leave and turn in the keys. And that's really important because that can allow you, if you have that eviction on your record, it can hurt you finding other places. So you really want to see, is this somewhere that you want to remain? But if you decide you want to move, you need to make sure that you have moving. Can you move? Can you afford to move your property? A lot of the rental assistance programs, like the City of Phoenix, are allowing you, if you move into a new place and you show them a lease, they can help you with your security deposit in your first month's rent. So if you decide to move, you can, and you find another place to live, you can then apply for rental assistance. And just to be clear, if you do move out and you do it properly, you will still owe a money judgment. Again, you could get a money judgment again. Your landlord will have that against you. But that's better than having an eviction on your record. You can always make a payment plan with your landlord. So you can always apply for government rental assistance. As we've talked about, there are a lot of places to apply right now. Attempt to set up a payment plan, even though that's not required by the CDC order. You need that if you're thinking long term. Think the payment plan is going to be able to help you come January 1st. And that payment plan can go past January 1st. It can be for the next year. Just don't sign a payment plan or proposal that you can't afford, because then you're going to get yourself in more trouble. Pay as much as you can. Be honest on the declaration, and keep copies of the declaration or any notice that you've done. All right, so that is us. What we're going to go through today. We have 13 questions, and so I'm going to try to answer as much as I can. Where will you find the recording after the presentation? It will be on our website. We have the PowerPoint on our website, and then the entire presentation will be on YouTube, on our YouTube channel. And so, but the PowerPoint, and as I said earlier, you can email me and I'll give you the slides. I'm happy to do that. All of the notices that I showed you, all of the tips, all of those documents all are on our website in English and Spanish. Do you assist with IRS issues? Oh, hi Pam, hi Julie. Do you assist with IRS issues? We assist with federal IRS tax debt. We have an IRS grant, so we can assist people resolve their federal IRS grant. So we cannot assist with state Arizona taxes, but we can assist with IRS tax debt. What is a declaration? The declaration is a statement that we showed in the website, I showed in the PowerPoint, that you sign. You have your signature and your date, and you are attesting to certain things. There were copies of it. I'll go back. I think I can. I'm not sure I can go back. 1 second. Here is the declaration. This is you're signing this, that you're stating that all of these things are true. We have this in English and Spanish on our website. Do these options apply to those in subsidized housing. This applies to all tenants. And if you live in subsidized housing, you really want to do everything that you can to not get that eviction judgment on your record, because you can lose your subsidized housing. But this does apply to all tenants if you qualify with those certain things. But if you are in subsidized housing, it does apply. Does a tenant still qualify under the CDC after a MTC? I think she means a motion to compel, served an oral argument hearing sent. Yes, the CDC order applies at all steps. What Maribel is referring to is that, especially before the CDC order came down, when we just had the executive order, if landlords thought, in the interest of justice, that even if the tenant complied with all of those things, they did not want them to stay on the property and receive that delay to enforcement, they were filing motions to compel, and they still can file motions to compel, that say that that's fine that the tenant did that, but we want the tenant out right now, well, within 5 days of this hearing, because in the interest of justice. Even if that the CDC order applies to that too. So if a tenant gets a motion to compel notice, and they have signed that declaration, and even if they haven't signed it, if it's true, sign the declaration and bring it to your hearing, give it to your landlord, it applies. Can the tenant provide the landlord and the court the declaration prior or at the hearing? Both. Give it, like I would put it as soon as you can to the landlord, because if you can avoid having to do an eviction hearing, that's good. It saves everyone time, but you can also have it ready to give it to the court. We have landlords that are refusing to accept partial payments. They can do that. Landlords do not have to accept partial payments legally. Under the CDC rule, the tenant just has to offer the partial payment, like to offer to pay what they can. And they would probably try to keep a record of it. Say, like, send it with a letter or email, like, I am offering to pay this right now, that I can pay right now. And then if the landlord refuses, it would be awesome to have that in a text or email. I'm not taking your partial payment. So legally, they don't have to take it. If they do, then the tenant can't be evicted for non-payment of rent that month. But all the CDC rules is that the tenant use their best efforts. So if you're trying to pay partial payments and your landlord's not accepting it, then you've used your best efforts and you can sign the declaration. Oh, lease at the end of the month. These are hard ones. What about if a lease ends at the end of this month? I understand it can potentially turn into a month-to-month, but can landlords decide not to renew the lease? Yes, they can decide not to renew a lease. That is a right they have, just like the tenant can decide, I don't want to stay there, my lease is coming up, I'm going to give proper notice and be out of here. But both parties can decide not to renew the lease. What happens then? Then if the tenant decides to stay past when the landlord has decided not to renew, the landlord then can call them a holdover tenant and try to evict them. That's in the normal circumstance. We know that the tenant, if they qualify for the executive order, could then give all of those things and to be able to delay the lockout until October 31st. What's in debate is whether the CDC order applies to those tenants. Again, I'm going to spell out my argument, and this is my argument, not the court's. However, many people in the country are thinking this too, but I would make this argument. Again, if your landlord is not renewing your lease because you haven't paid rent, I think the non-renewal of lease looks a lot like a notice of termination for non-payment of rent. I think there might be an argument. Are you going to win on that argument? I cannot guarantee that. I can't give legal advice here, but that would be an argument that I would think about at last resort. So as I said, it's a risk. You want to try many other options before you make an argument that you know that the Maricopa County courts probably do not agree. Does this have to be done every month? No. You just have to give one declaration. You do not have to keep giving ongoing declarations. A person finally pays rent, but next month or months later, they cannot. So if that situation happened, if you, right now you're paying rent, like let's say right now you're having problems, so you give the declaration, and then we get to November, you can pay October, and we get to November and you can't pay rent, I would give the declaration again. Like giving more documentation, I mean, giving a declaration again is not gonna hurt you, it's gonna protect you. So yes, give it to them again. And so if you can't pay, even if you've got assistance with a program or not, if you get assistance for 1 month, let's just say that's a really good scenario. So right now you get assistance, and let's say you get assistance for October, right? But November comes and you can't pay rent, but you're still under the CDC. So what you should do is try, you can try, if you try through the city of Phoenix, try through Maricopa County, try through ADOH, just put that application in. If they turn you down, you still used your best efforts. You just have to honestly say, I've used my best efforts. So you can try again, and you should try again then, and give the CDC order to your landlord if it happens anytime before the end of December. Is a copy of your PowerPoint available on the CLS website? It will be. Does the landlord have to accept the declaration? That's a really good question. I mean, a landlord doesn't have to accept anything, but the fact that you try to give it to the landlord is important, and then you should record when you did. And then you should keep a copy, you should record when you tried to give it to your landlord. If you did it by email or text, that's a record that you can keep, as long as you can show that it went to the right address. And then keep a copy of it to show the judge if the landlord tries to evict you. What makes the governor's order apply to lease terminations? What I do know is that if all of those situations, hi Sabrina, all of those situations apply to the tenant, the courts have said in their statements under their best practices and their guidance that it applies to lease terminations. And so that's why to non-renewals. And so they made that statement so that in all of that, and I can send, Sabrina, I can send you a copy if you don't have it of where they've said that it applies to lease terminations. The governor's order does not say it on its face. That was something the courts have interpreted and have given out. Is the best way to submit the declaration via certified mail with return receipt? Always. Return, you know, if you can do it by certified mail and you have the time to do it by certified mail, that's always the best. Is a stamp and an email sufficient as proof it was received? You know, certified mail is always going to be the better answer if you have the time to do it. However, if you don't, email and text will work, and the courts have said that they will accept notices that were during this time that were given to the landlord by email and text. You've just got to show that you gave it to the right address. I read this morning that it's being required that the declaration be formed and submitted in English. Does this apply to Arizona? I have not read that. We have it in Spanish also. I would need to look more into that to see if somebody, the landlord is not accepting it into Spanish. And what we can do for people is also do it in English and in Spanish if they need to do that. CLS can help with that. We have our forms. So if you go onto our website, you can see it in English and Spanish. But I have not seen that argument yet that it only has to be in English. And also nationally, I'm on a listserv with advocates who are working on this issue, and they have not raised it yet. But we will be on top of that. And if that is true, if only English declarations are being accepted, CLS will let you know, and we will change the materials. We want to protect tenants. What can an adult tenant not included on the lease do to avoid eviction? Pay rent. But if they, that would be the main thing, is to try to pay a rent, try to do all those things we talked about, make an agreement with the landlord if the landlord knows that they're there, or get rental assistance. But they're not going to be, if the adult tenant is not included on the lease, but the landlord knows that they're there, they could evict them. What is my email address? Great program. Well, thank you, Anonymous. My email is pbridge@clsaz.org. That's P as in Pam, Bridge, like Brooklyn Bridge. So pbridge@clsaz.org. If a landlord gives a non-renewal because they are selling the home, for example, or just not want to renew the lease, and it is not due to non-payment of rent, does the declaration apply? I think that would be a really hard argument, and I wouldn't make it. I don't think it's going to apply. If non-payment is not the issue at all, I wouldn't risk that. I wouldn't put the tenant in that situation. I would say it would not apply. When would tenants' right to damages kick in? That's a really good point. So I'm assuming we mean that the landlord, if the landlord violated the tenant's rights, as long as we're not talking about habitability issues, if the landlord violated, let's say the tenant was protected under the CARES Act, right? And the landlord violated, still evicted the tenant for non-payment of rent, or the tenant gave the landlord the declaration and the landlord still evicted the tenant. The tenant would still have to give the declaration to the judge. But let's just say in that situation, something happens and the tenant still gets evicted and they've done everything right. Then first of all, the tenant should do a motion to vacate the judgment, and they could be entitled to damages, although it would depend on the situation, and I would call Community Legal Services, SALA, or DNA in that situation. One thing tenants should be doing right now is if they've given the proper declaration and they do get a summons, we are creating like motions to dismiss, but a pro-per tenant by themselves would just have to show up with that form and say, Your Honor, I want to dismiss this. I gave this form, and here's the form now. I gave this declaration to the landlord. But I do think there might be damages, but I think that we would have to look at that on a case-by-case situation. This is from Jeff Katz, who is the manager of the housing unit at CLS, and so he knows a lot. I can't imagine what he's asking me. Does the moratorium apply to evictions that are brought after foreclosure where the occupant is the foreclosed homeowner? I do not think so right now. Again, like I think we have to limit it to if it's a non-payment issue, we might be able to argue it, but I think we need to look at that more carefully. I don't want to say blanket yes or no and then be wrong unless we've looked at that more carefully. David Engelman. David Engelman is the managing attorney of our tenant eviction assistance program. That's that program for all of the city of Phoenix who are at risk of eviction or risk of their house. They can call that number. Can a landlord continue to prosecute a forcible action to a money judgment for rent only, not possession, if the CDC declaration provided a landlord after forcible filing? If it's not a forcible action, let me just make sure I understand that if the tenant has turned in the key and moved, right, if that's happened, and when I was talking about they can go after a money judgment against you, that would be a civil money judgment. They can't do a forcible action if they're not removing the tenant from the property. So a forcible action means that you're trying to get a judgment to get possession of the property. So if possession is not the issue, then it's not a forcible detainer. It's a normal civil monetary action. So if the CDC declaration is provided to the landlord after the forcible filing, the forcible action itself has to stop. There's no jurisdiction to continue with the hearing, that the judge cannot file, the judge cannot do a judgment in that case if the tenant has given, even at the hearing, the notice to the CDC. And I've seen that discussed several times nationally also, that anywhere in the process it has to stop. So in that situation, the landlord can't just continue the forcible action for the money part, because it wouldn't be a forcible action. There's no jurisdiction for the forcible action to continue. Any thoughts on pretextual evictions? Anything we should be looking for? Evictions where non-payment is present, but the eviction is filed under undergrounds, like alleged material breach. That is always a risk, right? So a landlord knows a tenant hasn't paid rent. One thing all tenants should be doing is making sure that they're complying with their lease. This is not the time to have unauthorized guests and barking dogs or break your lease in any way. No criminal activity, don't do it. Because, you know, if the landlord does say the tenant violated their lease some other way, then it's just like a normal landlord-tenant situation where the landlord's got to prove it. The landlord has to have proof that the tenant did a material, and it has to be a material violation of the lease. But my advice to tenants, again, is now until December 31st, tread carefully. Don't do anything you think is going to violate your lease, because again, the landlord may try to do that, but they've got to prove it, that you violated your lease. If sending a notice by certified, this is Jeff Katz, again, our housing manager, so he has a comment that, and I would listen to him. If sending a notice by certified mail, also send by regular mail and note on top of the letter that it's sent both ways. Good advice. Did you hear that? So we're going to do, Jeff is saying, do certified mail and regular mail. Do it both ways. That's best practice that most courts accept. He's absolutely right. If you have the time to do that, if there's time enough, that's going to stop. The landlord needs to get it. Go do that. David Engelman, Pam, I agree with your answer to my question. Yay! People should be aware that some landlords council are seeking to obtain judgments for rent only. That is a case I would like to see, and that's problematic. And I think that we need to look at that on a bigger picture, because that shouldn't be happening. And he said, in reference to the last comment, I meant landlords council are asking the justices for judgment of rent after eviction action is stayed by CDC. No. That shouldn't happen, because there shouldn't be there's no, like I said, no jurisdiction. They can file in civil if they want to, but they shouldn't be, like, you can't go after. A forcible action is to be able, like I said, is a fast summary proceeding to get possession. We have civil remedies for money that people can always do, but again, I think that's an impact issue that CLS, SALA, and DNA should look at. We need to make sure that that is not happening. You can do a proof of mailing at the post office, cheaper than certified. And that was a comment by Anonymous. Okay, Tim Finn, is the $100,000 penalty, that just, every time I have to say that word, it's so extreme, for violation of the CDC moratorium, a federal civil remedy, a criminal penalty, or something else? I don't know. I don't know, because it says that you can get civil penalties, and I would say it was a civil penalty, but the problem is that the order says that you can also receive criminal and even imprisonment on the order. So I don't know. I don't know that answer without looking that further. My brain stopped at 100,000. Like, who can pay 100,000, landlords or tenants? But I just think that was a way for the CDC to say, we mean business, you better comply with this. But that's interesting. I would like to know. I think that I did all the questions then. Those were great questions and they made me think. And there are a couple I didn't know that I think we need to, there are a couple issues that were raised that I think we need to watch out for. I do think that just like when the CARES Act happened, when the CARES Act came down, people were confused and there were mistakes made. I think we need to watch for mistakes, and we need to make sure that everybody understands the law, tenants and landlords. And if we hear about people, people not complying with the CDC order, or like in an area where there are certain, landlords doing things that we think that are not in compliance, then please raise those to CLS. Sometimes even when it's a bigger issue and it's ongoing practice, it's somewhat easier sometimes to fix than individuals making mistakes. But we want tenants, the goal for us is to keep tenants housed, to not get judgments on their records. And that's why the CDC order is so important for tenants right now. It's exciting, but we also need to think about January and not set people up to fail. That, like I said, we want 2021 to be a better year than this year. Don't want to start people in a position where they're going to be evicted within 2 weeks of January 1st. So I believe that I have now answered all questions. Oh, I think so. I'm not seeing more. Let me just make sure. You can always email me. I gave you my email. I don't see anymore. But as I said, you can always email me with questions if I did not get that your questions answered today. If there is clarification by the CDC or the courts, then CLS will update our materials and we will get it out. If there are changes, anything that we learn, we will get it out to the community so that we can all learn as we go. But I want to thank you so much for coming today, and again, please email me if you have any questions about this. Thanks, and have a good day.